one day back, my lord. It's a jail appeal.
Lordship, I beg to mention for
Lordship is upgrading
Immediately after admission.
my lord. All right.
Lordship for listing the criminal petition, which was listed earlier on 11th of March. Service completed, but thereafter not listed. Any date, my lord? Order matter. my lord.
Place this matter for orders on a date to be fixed in the registry in the week commencing from 19th of August.
Any date, my lord?
We are not fixing the date. This will fix that. It is
Lord.
week commencing from 19th of August.
Lordship.
May I please? I beg to mention for listing of a criminal petition, my lord.
So pending one or
20 months.
same week. On a date to be fixed by the registry. In the week commencing from 19th.
May I please, your lordship, I beg to mention for a listing of a criminal petition, my lord. For fresh listing, my lord, this motion matter.
When did you file?
My lord,
When did you file?
on 18/7, my lord.
18th of July.
On Monday, my lord, because my lord,
See if it is not listed on Monday. Make a mention.
Monday daily list is not listed, my lord. On daily list, my advance list, my lord, I have not found, my lord.
Find out. If come in a supplementary. If it doesn't listed on Monday, you make a mention on Monday.
Monday, my lord.
Please, Lordship. With the consent of the other side, I beg to mention item number 6, Lordship.
Hmm.
It's a dispute between landlord and tenant, Lordship. The petitioner is trying to settle the matter amicably, Lordship. The matter will be taken up, Lordship, after 4 weeks, Lordship.
Have you informed? Yes, you are.
Yes,
On the prayer of the council, the parties. Place this master after 4 weeks on a date to be fixed by this.
Lordship, interim order may be continued, Lordship.
Interim order passed earlier. Shall remain in court. The next date of listing of.
Lordship, the revision petition may come on Tuesday for order salam. So, because the last it is came 22/7, Lordship not listed. It is, yes, another is in April, Lordship. So Tuesday in order column, Lordship.
Tuesday, you see, if we keep the matters for admission and orders, we cannot touch his
Yes, yes.
hearing.
Can happen.
So not on Tuesday or Thursday.
Because one matter is fixed on 1st of August notice by MBWA. So we filed additional affidavit which is required before first.
You first it on first together. That. On
First.
first.
Problem.
May I please, your lordship? Lordship, I beg to mention item 2, lordship. Item 2, lordship. With consent of the other side, lordship, the matter may be adjourned for today, lordship.
You inform the other side.
Yes,
Yes, ma'am.
My lord,
You are appearing, madam.
I am appearing for response number 2, my lord. A date may be kindly fixed.
Give us a date among yourself. Select it. You select, give us a date, both of you select and give us a date. Item 2. Yes, Mr. Sayola.
Next, August Labane, August Labane.
Mr. Sayola. Yes, what's your matter?
Yeah, please, your lordship. Lordship, item number 40, my lord, joint prayer. The matter will be listed on 20th of August, my lord.
First, 5th September.
Item 40, my lord.
Mr. Kulika.
5th, sorry.
Madam, just a minute. Which August?
20th of August, my lord, Tuesday.
As agreed on the prayerable line of the 40. Please this one. 20. Yes, ma'am.
5th of September.
Lordship, there is an interim order, may be continued, lordship. In item 2.
Sign over কিন্তু আগতে extend one extend নকৰিব কোনো দিনে নকৰিব আগতে extend করতে not extended to next
May I please?
yes
I beg to mention a criminal division petition for listing, your lordship, on Wednesday, your lordship.
when did you file it's a pending
It
matter
was pending matter, your lordship.
Wednesday
Wednesday, lordship. Deeply obliged.
May I please, your lordship? With consent from the other side, I beg to mention item number 14. Matter may be at 14, 1 for you.
yes what's your prayer
Matter may be adjourned for today, your honor.
after 2 weeks on a date to be fixed by the registry
Lordship, two criminal petition. It was last listed on 25th of 22 of May, lordship. On that day, lordship, I was not here. So lordship, matter could not be heard. So lordship, me taken up a motion, lordship. And next week, lordship, in the Monday, Tuesday. Motion, lordship. Motion.
31st. 31st, not on Monday.
31st, Lords,
Wednesday.
Lords.
May I please, your lordship, item number 30, your lordship, I am appearing on behalf of respondent number 2. Senior could not join, come today due to some health issues. Let the matter be taken some another day.
Item number 30.
Yes, sir.
Have you
Lordship.
informed the petitioner?
Yes,
You have informed
yes.
the priority council for the parties after 3 weeks. Yes, ma'am.
I beg to mention criminal appeal matter 199/2023 to be listed on an urgent basis.
Why? When it was last listed,
4/10/2023.
thereafter it hasn't been listed.
Pardon?
Thereafter it was not listed.
No.
5th of August.
No, please, your lordship. I beg to mention item number 4, my lord. It may be taken after a week, my lord. There is a chance to settle the dispute, my lord. This is the case of maintenance, my lord.
Yes, ma'am, she was here. Miss Visita Sharma, she was here, sitting here this time. Item 5,
4, my lord.
4. The priority petition. The 2 weeks on it. Yes,
May I please,
Obliged,
lordship,
ma'am.
lordship, I beg to prayer for listing the criminal revision petition. It was listed 29/04/2024 and supposed to be listed after 2 weeks, but not listed yet, lordship. So lordship listed the matter 31st July.
May
Yes,
please, your lordship. I beg to mention item number 23.
yes.
23. Due to some personal difficulties of my senior, he is not in the position to appear before this honorable court.
So what's your prayer?
In adjournment for a week. And interim may be continued, lordship.
These are order matters. Let the matter reach, you'll see. Let the matter reach. Yes,
May I listen? Regarding item number 14, my friend had already mentioned, this is an urgent matter, next week when I needed, there also may fix the date.
It may be fixed, my lord.
There is no stay order, but I am suffering, he is not paying anything, the family dispute, 125. Possible. There is a fix the matter,
Next week,
next week not possible, possible on 7th.
Well-
7th. Yes.
Diploma.
May I please, your lordship? With the consent of the other side, I beg to mention item number 15. Due to some personal difficulties, the engaged counsel of the petitioner could not be present today. So I pray that the matter be passed over for the day.
May I please, your lordship. Lordship, I beg to mention for, lordship, I beg to mention for listing, my lord, any date next week.
It's a pending matter or what?
Criminal matter.
It's a
Criminal
pending matter or it's a new matter?
lordship.
Which matter is pending?
Yes, my lord. Next week, any date, my lord.
7th.
Most of it.
Yes, do you have the case diary?
Lordship,
Do you have the case diary?
lordship, case diary not received, lordship.
It was received by Mr. Parasar. As per the order of the court.
Lordship, after some time, then lordship,
Verify
lordship.
and this Zokalabunda PS case number 47/202. Find out. If it is there, we'll pass also.
Lordship.
Your lordship, I was actually having, if the matter could be taken next week. Actually, the senior counsel is on legs, so the matter may be taken after 2 weeks.
Let them find out whether there is a case diary or not. Otherwise, we will take it up the next week.
Okay, no problem.
But you may kindly peruse the 3rd of August 2022 order. Respondent number 2 has also represented, my lord.
Miss Sangeeta Khataniar appears. Poribedu আছে, আজি মিস করিলেন জি
Posted for hearing?
ম্যাট্রিমোনিয়াল ইস্যু নাকি
No, no, still in 156 order.
Oh, this is 156 3. One line is there, of course, in the complaint that he has approached enforcing agency and he did not get any relief. One line is there. He was refused the same by the law enforcing agency when approached. But nothing particular.
The law says, my lord, it should be supported by evidence.
An affidavit also.
Affidavit is there.
So he has to
154.
150, he has to
154, 3.
take recourse to that after that. 154, 1 and 3. But then only one line when approached.
Nothing, it's a vague.
No, it's a vague one.
Priyanka Srivastava.
Huh?
Priyanka Srivastava.
Okay. Sapiri Vasu also.
Come to page number 40,
Yes, 40 only I'm reading.
paragraph 8.
8, last line. He was refused the same by law enforcing agency when approached. So he approached, it was refused. So he has come under 156, of course, but it's a vague statement that he took recourse under 154, 1 and 4, both. It's not there. Cognizance Lale.
You already wrote on the championship.
Oh. ডিসপোজাল করাটাই ভালো হবে ঠিক আছে
Earlier, the petitioner preferred a criminal petition.
আচ্ছা
Earlier, a petitioner preferred a criminal petition.
আচ্ছা
It was dismissed.
ও
The same GR case.
আচ্ছা সেম জিআর
Madam,
দ্যাট আই এম নট অ্যাওয়্যার
no, that is part of the report.
আচ্ছা
That is part of the report.
Now,
সাবসিকুয়েন্ট 482
no, this is second 482.
হ্যাঁ
Now, first ground, this point was not taken.
হুম আচ্ছা 156(3) point was not taken আচ্ছা The subsequent 482 petition on a new ground, of course, is not encouraged, but I think
It's not a new ground.
not a
It's a-
new ground, it's a law point.
It's a no, that is the reason. But the petitioner failed to take that ground. Can he take it here again?
In another case, I was supposed to see whether subsequent 482 petition, how, I mean, in what circumstances it is barred. Let this come up after that case, we will see.
Yes, yes,
It
I will satisfy.
I go to dismiss for withdrawn, withdraw.
No, no, no.
Earlier,
That-
the
that was on the-
petitioner
it's
approached
a-
this court
Huh,
for crossing of this proceeding arising out of the same complaint petition.
no, actually. Before cognizance, perhaps. I think.
No, no.
After.
Madam, their challenge was FIR and the charge sheet.
Okay.
Here we are challenging 156(3) order. And I will show my, there is no bar. And this principle of adjudicate or constructive adjudicate has no application in criminal jurisprudence. Lordship, may kindly post it for hearing next week.
P. Burman. আরো একটা কেসের মানে we were supposed to see subsequent 482 petitions after some notice वगैरह is issued and withdrawn, particular circumstances, how whether there is any bar, what. what is that?
There are judgment.
There is no bar.
And there is no bar, it should not be encouraged, but no bar, I think. That is the word used.
Not on the same grounds.
Challenge. Come to page number 61.
Lordship.
Para 11.
The respond number 5 had
No, no,
respond,
that on.
that on
Page
8/7. 2015, respond number 2 had filed a complaint case against a petitioner before the Honorable Chief Judicial Magistrate, which was later registered as Chanmari PS case. I think the same one now.
Yes, yes, yes.
Huh.
Everything is same.
2015, under 420-406 of the IPC.
Here,
I think
the petitioner did not take the thing of 156(3).
that was not taken. In the said case, charge sheet was submitted under section so and so. Subsequently, by the order, judicial magistrate cognizance of offence was taken in corresponding year. The said case is at the stage of
And he-
appearance, and the next
this-
date is
this-
so and so.
Yeah, he did, in the said petition, he did not plead that the taking cognizance of by the learned magistrate was bad.
Acha.
That is, it was not raised. Now whether. we'll
This
have
is
to do it.
pending. This case is pending.
That was
Stayed.
Disposed of.
That was dismissed.
No, that criminal petition has been dismissed
Acha. On merits.
on merits.
Only challenge is a civil nature. Allegation is of civil nature. That was rejected by this court.
Grounds of challenge have changed, but the grounds were available that time also, the
Yes.
present grounds.
That's the reason,
That's of course the,
whether he
Yes.
will have a second chance or not.
in these facts. I'm yet to go through
Go
that
through, go through.
decision, so I'll go through this also.
Mr. and not. Also for the MSS done. No representation on behalf of the letter number 2. Though names of 2 councils have been reflected. Okay. Got this. The same that the petitioner may have preferred a criminal petition under section 483 for causing the FIR relating to Sunbury PS case number 444 of the 2015 and the search sheet number 13 dated 02/02/2018 filed in the said Sunbury PS case number 444 of the 2015 against him corresponding to GR case number 7291/2015. Where
You are not hacking me, right? Happening, you will
Say-
come to law, no, I will.
Sunbury PS case number 444 of the 2015 was registered on the basis of the complaint dated 08/07/2015 filed by the respondent number 2. Before the Honorable Chief Judicial Magistrate Tambok Metro Guwahati. The court, a coordinated bench of this court, after hearing the parties
So most of them.
criminal petition being criminal petition number 176 of the
No, complain only, please, sir.
coordinated bench of this court after hearing the
Was that
parties
okay? I'm to know.
by order dated 16/06/2022. This say criminal petition number 176 of 2022 of the petition. Thereafter, the petition on 22/07/2022 filed this criminal petition challenging the said complaint petition dated 07/08/2020. Dated 08/07/2015 filed by the respondent number 2 before the learned CJM Kampur Metro. That was transferred to the court of learned State complaint to file under section 156 in bracket 3 of the same. Being complaint case number 1389C of 2015. Which the learned magistrate by order 0407/2000. Referred to the Sunbury Police Station under section 156 TRMC. Directing the officer in charge of the said police station to register a case, investigate the matter, and to submit final report immediately. Pursuant to which the Sunbury PS case number 444 of 2015 under section 420 of 406 FPC was registered corresponding to clear number 7291 of the case in which search sheet was filed against the petitioner on 02/02/2020, which was challenged by the petitioner in its earlier criminal petition number 176 of 2002. It is seen from the annexer J, copy of the criminal petition number 176 of 2022. Annexed to this petition by the petitioner that in the said criminal petition, the petitioner did not take the ground that without first approaching the police, without first complying the provision of section 156(1), 152, the respondent number 2 could not have filed the complaint petition under section 156. Placed on 19th of August, enabling both the petitioner and the respondents to make their necessary arguments in the matter. Till then, the interim order passed on 03/08/2022 shall remain in force till then.
Lordship has fixed it
Parliament, it's still on
19th of
19th.
August.
19th of August.
Till that time, the interim to continue.
It is there.
I'm listening.
May it please the lordship. Lordship, my senior is on legs on some other court. Kindly the method in the class of the time.
Section. Key section. Oh, okay. Post title of Diana. Okay, 294. He's asking for time being.
Will not allow. His senior may be in some other court, let it be, let him argue.
Hmm. এখন FIR খনৰ পিছত আকৌ তোমাৰ নাই। FIR খনৰ পিছত আকৌ কমপ্লেইন দিছে। FIR দিছিলে, ফাইনেল ৰিপৰ্ট দিছিলে। তাৰপিছত এখন কমপ্লেইন আফটাৰ FIR। তাৰ আজি পিটিশ্যন টাইপ। তাৰপিছত এইটো কি হয়? অ'। উম, উম, DD আছে না, DD কেছে আছে না? হ্যাঁ, হ্যাঁ। হুম, divorce petition আছে। হুম, restitution তো কি হবে? হ্যাঁ, হ্যাঁ, তো two zero one to three zero. 294, 315 is okay. 34 is okay. 201 is disappearance of evidence না জানো? ওই বাচ্চাটা ভেরিফাই কেন করেছে? Disappearance এর। ও, Nenon দিয়ে still one করে। হ্যাঁ, দুটো মিলে। হুম।
Who is appearing for the respondent?
He is there.
Respondent number two. Private respondent.
The ingredients, Lordship will see 294, 315, and 201.
See, initially there was a, he lodged an FIR.
Huh. Lodged an FIR,
The final report was filed,
there the final report.
right? Then he filed a complaint.
Yes, kind of Narazi.
Not exactly Narazi,
Hmm.
because we do not know at that stage, after receiving notice, he has acted upon it.
Acha.
If before accepting that final report,
Hmm.
the learned magistrate might have issued notice to him or the concerned police person,
Hmm.
because he being a constable
Hmm.
in police, he might be aware of the proceeding.
Yeah.
And after filing the, it is clear that in that matter, the respondent number two, the informant, he himself, the complainant himself, stated that it was final form. Ultimately, matter was closed.
Hmm.
Thereafter, he logged in.
Hmm.
And it appears clearly, because an additional affidavit has been filed by the petitioner, wherein the petitioner, the complainant clearly stated that at the time of his wife, when left her
Hmm.
matrimonial home, she was 6 months pregnant.
Hmm.
And that, do you have a copy of the additional?
No, additional affidavit I don't have.
That's what the petitioners have brought in through.
Acha.
So that the petitioner was fully aware.
Hmm.
Now,
That she was pregnant by 6 months.
no, there are, just a minute.
That's an additional. affidavit.
Second 49.
I have it. I have one copy from him.
Now, if you have the cross-examination of PW1,
Hmm. PW1,
that is the complainant, respond number two.
Pituram Borman, yes, cross, yes.
Just read it, you know.
Lordship,
Just read it for yourself and you'll know.
Pituram Borman complainant no জানে। Narazi petition is that one which has been registered at CR case. It will Narazi. Fifteen nine 2017, 498, 15/9. Bishop. 15. March. Hmm? No, 9 months of not marked the syndrome. He was pregnant for 9 months. I have not submitted any hearing. Not married. My another brother is a cultivator. My everyone will have you say.
I'm sorry, my lord.
That I have never met many issues rather. But one, that is suggestion that he married again and he has 2 children. That is a suggestion which he denied.
She or he?
He,
No, this is because what happened, the complainant, after filing the submission of the final report,
Hmm.
he filed a protest petition.
He filed a protest petition.
That protest petition was accepted.
Huh.
and
It was
treated
registered as.
complaint petition.
Hmm.
And accordingly, complaint was and section 294, 315, 34.
Hmm.
But what is the ingredients of section 294? Against the present petition?
In the FIR, of course, in the complaint and the FIR, that she had rebuked him and with slang language, those things are there. Lordship will see that word. This in the FIR, he himself went to bring her back and she threatened her with dire consequences with criminal intimation and flatly refused to come back without any reason. Rather asked me to live with her parents' house as Gharjamai, which I denied. And then bad language got somewhere. And that little before that, she usually behaved with me with ill-treating towards me by uttering obscene acts and filthy words. These are there even in the complaint.
But it has to be in a public place to attract 294.
Huh.
Simply uttering obscene, filthy words and doing obscene acts itself will not attract 294. The essential ingredient of 294 is that it has to be done in a public place.
Public place is again defined a number of times by Supreme Court by enlarging the section.
Inside household and all.
Hmm. But in presence of Supreme Court is a public place in presence of so many people. পাহৰি বহুত না বাৰু। ক'ব লাগিব।
Come to page number 17.
Yes, 17 only I'm reading FIR. কিন্তু কমপ্লেইনটোত আকৌ সেইটো নাই। No?
No.
Complaint to 220. Hmm. 314 তো বল ঠিক আছে 314 হয়েছে নাকি হেৰি হেৰি নহয় জানো মিসক্যারেজ নাকি বা টার্মিনেশন আচ্ছা আৰু 201 is disappearance of evidence. So disappearance of evidence আহিব না? Oh, oh, dead body টো পেলাই দিয়া বুলি কৈছে। Hmm. Allegations are that only, কিবা খাইছিল so that it is not born alive. Hmm. Page 32. Disappearance of evidence. Body to peলাই দিছে, 32. Hmm. So, reason for the washing is not there. Hmm. Work probably earlier incident aborted her pregnancy at her parent with prenatal home. At her parental home at her prenatal home care without my consent and with intent to prevent the child being born.
In his complaint petition, page number, it starts at page 25.
Yes.
There is no such allegation of section 1294.
No, there is, Lordship will see, page 28.
Hmm.
28, first paragraph.
Hmm.
One day the complainant went to the house of the accused person to bring back, but that day all the accused person misbehaved with the complainant and scolded him with slang languages. Besides, they threatened the complainant with dire consequences.
Where?
Lordship?
Where? Went to the house of the accused.
Has to be in the house of the accused persons.
So 294.
Huh. That public place again has to be
In the house.
in the house where so many people were there. That public place is interpreted a number of times.
The residential house cannot be a public place.
The allegation 315 Lordship is there.
315 is there, but you come to this page.
Medical certificate shows unknown region. And 201 they tried to dispose of.
Case number 32 and 33,
Yes, 32 I've seen here shown me.
and the say 35.
35 also. It's in the hospital. Yeah. Due to unknown factors. Page number 34, 35 says, due to unknown factors.
There are cross case and many things.
There are cross cases. Cross case was of course filed later. 498A case is also pending.
There are also 315.
DV case is also, there's so many issues. ইতে মানুহবোৰে কি কৰে নহয় সকলো কথা মৰিব হ'বই দেখোন ইমান হাল্লা হুল্লা কৰি থাকে মানুহবোৰে ভালকে থাকিব নোৱাৰে মানে public
In the DV case,
go আৰু
maintenance, in a DV case, maintenance was given to her.
given
Then though there was a direction for conjugal rights.
but execution was
paid
dismissed.
Because the complainant.
She was given to, she was also ordered to stay in his household, I think,
but thing is
separately.
That execution was failed because he did not appear.
Then again, divorce is pending, I think.
Divorce to instruction.
No.
Now, complainant is married,
Lordship,
complainant is married,
Lordship.
complainant is married.
Complainant is, that is one suggestion had come, he is married with 2 children, but
Complainant has filed a divorce case presently, it is pending.
no, whether he is married.
What happened with the divorce case? Mr. Khan,
No,
Divorce case is pending. Divorce case, I have no instruction, madam. This is a cross in the divorce case itself. Annexure 16 that we have submitted. Could you also divorce case from Power Mono, which is shown in the divorce case itself. Annexure 17, page 98, Lordship, the cross examination is a cross examination in the divorce case itself. That is pending, it's 23, 2023.
the matter can be sent for mediation, I think.
okay. If the party agrees, then only.
Damana?
The criminal case for put mediation.
No, these offenses are not there.
On the basis of that award, also case,
All the cases can be.
do an mediation. Gidek Guneko,
Money to 294.9, 315 also 9.
315 অকমান আছে ন? He had taken some medicines.
That subsequently death child for Iman in the syllabus they're going out. Medicinal potential to point nine.
নহয় process থাকে তাক সুধা নাই ৰবাচোন এইটো চিপত
পিছত কিয় ক'ব পাৰা?
ডিভোৰ্স কেছ ফাইল কোনে কৰিছিলে?
এইটো ডিভোৰ্স কেছ হয় নে?
Divorce case, Pitturam petition, no? My lord, I have just taken the instruction, the divorce case is still pending, PW1 is complete, my lord.
No, that's the old matter.
Now it is fixed for PW2, the divorce case. And divorce case was filed by the complainant, husband,
That's the old matter.
my lord,
Divorce case was filed when.
by the
51.
husband, the complainant hearing. This case, my lord, is itu case itu dia from government posting of itu ya udah penolak dia kan kalau itu terus di criminal case gitu pasti wajib. Nanti cuma apa? One question. Brother, mother.
He's ready for meeting. If attempt can be made,
Just tell us one thing. It is the complainant who filed the divorce case. Right? Because the clear ground is that,
Complainant filed divorce case.
what is,
Lordship,
you can close this case.
close this case. As far as FIR and this case is concerned. Divorce and all those are pending, let them be remain.
Because it is his seeking and, no point of dragging this matter.
No, that can be a way.
basically.
My submission is there are ingredients, Your Lordship. Divorce case, the background of the divorce case is that prior
What's 294? What is the first explanation for it 294?
I have seen cases, of course, public has to has access.
Lordship,
Inside the
482,
building,
Your Lordship, quashing the case, Your Lordship, quashing the complaint case, Your Lordship. Under 482, the ingredients of, there are allegations, Your Lordship. Prima facie, there are-
Allegations are there, so as the provisions of 294 and 315 first.
And admittedly,
See the ingredients of 294. What are the quantities? Read 294.
yes, whoever to the annoyance of others does any obscene act in any public place. Or B, sings, recites or utters an obscene song, ballad or words in or near any public place. In or near is also there.
Where is it mentioned that it is the house of any public place?
definition of public place, Your Lordship, as Lordship knows, Your Lordship, number of cases, Your Lordship. It has been widely interpreted, Your Lordship. And regarding the other sections as well, admittedly, the dead body of the stillborn child was disposed of by the mother without the knowledge of the father, Your Lordship. It is an admitted fact, Your Lordship. So the ingredients of
Lordship, when it has been raised that the complainant does not have the financial capacity, then it becomes imperative upon him to prove that he has the financial capacity to give an amount. And the amount here in Lordship is rupees 15 lakhs. Not a small amount, Lordship. And the partnership is also a registered partnership deed, Lordship. Wherein it had been stated that the account in question from which the check was issued was the official account of that partnership fund.
Yes, you want to say, place something? Yes, which judgment you want to place?
Lordship.
Which judgment you want to place?
Lordship, regarding financial capacity, Lordship, there is a judgment of Terry Singh, Lordship, Supreme Court.
How it will help you?
Lordship, in that judgment, Lordship, the Honorable Supreme Court has stated that 'Lordship, in this case, the Supreme Court has categorically stated, Lordship, that at the time when,
Citation, please.
Lordship,
Citation.
citation is,
Reported in
Lordship, 2022, 3 SCC 442.
Two thousand 3 SCC.
Yes, Lordship. Civil.
With the 14 name. Give it to us, give it to us. Give that copy, we'll give it. Give it. The term. Yeah.
There is also the case of Lordship Basa Lingappa, Lordship,
Hmm.
during the financial capacity. Specifically, Lordship, hearing in the case, Lordship, and in the advocate reply, the notice, reply the advocate notice, the.
That we have seen,
Yes, Lord.
that you have given only for the
Yes, Lord.
provident fund.
Yeah.
We mentioned.
And Lordship, please have a look at page 36, Lordship.
Hmm.
Yeah. Paragraph 9.
Please come to page number 136, judgment of the London Magistrate. Read para 22 onwards.
In his cross-examination, the PW1 has admitted that he has not submitted any income tax statement or his bank account statement. He admitted that in his complaint petition and evidence and affidavit, he has not mentioned about the mode by which money amounting to rupees 15 lakhs was given to the accused or the date on which the money was given to him. He stated that he has not submitted any sale lead to show the type of land sold by him. He has not mentioned from whom he had taken the loan as stated in his evidence on affidavit. He has not submitted any work order or audit report of the firm. He admitted that the check in question is a bearer check. PW1 denied the suggestion that he had misused the check of the accused. He further denied the suggestion that he had joined the accused person's firm as an employee. During the cross-examination of the complainant, the accused put across questions to the complainant regarding the financial capacity of the complainant, to which the complainant stated that he had arranged the loan by disposing of a plot of land as well as availing private loan at the rate of 10 to 15%.
Go ahead.
The accused, as DW1 deposed, he had issued the check in question for paying electricity bill. He had not filled up the check. He admitted his signature on the check and deed of partnership. He deposed that when the complainant told him about his financial problems, he told that he can look after his work, and he paid him honorarium. He further deposed that he had not filed any FIR or complaint against the complainant for misusing his checks. Accused admitted that HDFC Bank account number of Satyam Enterprises 26 Iman. It is admitted, accused side submitted that since the complainant has not been able to adduce any evidence or produce any document to show that the accused is liable to pay an amount of rupees 15 lakhs in discharge of any debt or liability, so the accused should be acquitted. The accused has not denied the issuance of the check. He has also admitted his signature on the check. Bare averments do not aid the case of the accused, as he had not led cogent evidence to supporting them. What has to be seen is the existence of liability towards the complainant when the check in question is presented to the bank. It is thus clear that for whatever reason, if a check is drawn on an account maintained by a drawer with its bank in favor of any person for discharge of any debt or other liability, the ingredients of offense under Section 138 of an act gets attracted. In case the check is returned dishonored, the check amount remains unpaid within the statutory period despite service of notice. The defense above, therefore, of the accused is no longer relevant in the given facts and circumstances of the present case, as the accused has been unable to establish the non-existence of any liability as on date of presentment of the check by the complainant. The accused was unable to elicit anything material from the complainant during his cross-examination. Rather, the complainant held strongly and consistently to his contention, making his story more credible vis-a-vis that of the accused. Further, the accused has not brought on record even a single document which could show that the check was not given to the complainant for the purpose as alleged by the complainant. It is to be noted that though the accused has examined himself in the present case, he has failed to substantiate his claim. Mere suggestion to the complainant or mere explanation given in the statement of the accused under Section 313 CRBC that the check was given for payment of provident fund does not amount to proof. Since the instant case, the accused has failed to lead any convincing evidence to aid him in discharge of his owners, the presumption of law operates in favor of existence of debt or liability. I am of the opinion that defense set up by the accused is neither definitive or nor consistent with his innocence. It was the sole burden and duty of the accused to prove the absence of liability by raising probable defense. However, he has failed to discharge his owners except for making bare averments. The accused has not led any cogent defense, which could be termed as probable defense. Could I go further?
Please go ahead up to para number 34. That will cleanse everything. Yes. Whether there is a requirement of interference with this order, that's what. Please come to page 20, para 26.
What?
Continue.
In my considered opinion, it is now well settled that in case the accused admits his signature on check in question, there arises a presumption in terms of Section 118A and 139 of the NI to the effect that the same was issued for valid consideration and in discharge of legally enforceable liability. Section 118A of NI Act provides that until contrary is proved, it shall be presumed that every negotiable instrument was made or drawn for consideration, and that every such instrument, when it has been accepted, endorsed, negotiated or transferred, was accepted, endorsed, negotiated or transferred for consideration. Further, Section 139 of the NI Act lays down that it shall be presumed unless the contrary is proved, the holder of a check received the check of the nature referred to in Section 138 for discharge in whole or in part of any debt or other liability. Thus, Section 139 of the NI Act puts the burden on the accused to prove his defense. However, the accused has to prove his defense on the balance of probabilities and not beyond reasonable doubt. Once the presumption is displaced, the accused is liable to be acquitted. Thus, as laid down in catena of decisions, it is an established law that onus lies upon the accused to rebut the presumption and to establish that the check in question was not given in respect of any debt or liability, with standard of proof being preponderance of probabilities. Therefore, it becomes critical to examine whether the explanation of the accused coupled with the evidence on record is sufficient to dislodge the presumptions and advises under section 118 and 139 of the NI Act. In this case, the primary defense of the accused is that he had issued the check for payment of provident fund. The accused has averred that the complainant has misused the impugned check and has filed a false case against him. It is alleged by the accused that some of his checks were kept in blank signed form for payment of electricity bill, rent, employee salary, etc., which has been misused by the complainant. However, the accused did not file any FIR or complaint with the police regarding the misuse of his checks by the complainant. Moreover, learned counsel for the complainant submitted that during his cross-examination, the accused has stated the complainant opened one office at Pathor Quarry in the name of Satyam Enterprise. And he also admitted that he had kept most of his documents like work order, checks, etc. in the said office. Thus, there is discrepancy in the statement of the accused. On one hand, he stated that he had executed exhibit 1, but no work was done with the complainant in pursuance of exhibit 1. On the other hand, he stated that the documents like work orders were kept in the office of Pathor Quarry. The accused also admitted in his cross-examination that in head office of the firm, there are 10 employees. The complainant decided how much was to be paid to the employee. If at all no work was done in pursuance of exhibit 1, why for 10 employees were employed in the said firm? Again, exhibit C, which is the Employees Provident Fund scheme related document dated 13/8/2013, accused stated that there are 20 employees in his firm. Another discrepancy is that the accused stated in his cross-examination that the disputed check was issued for paying electricity bill, but is in reply, exhibit E, to the advocate's notice, it is stated that accused had issued the disputed check for making payments toward provident fund. On one hand, accused stated that the complainant is his employee whom he had paid honorarium. On the other hand, he admits the execution of exhibit 1, acknowledging the complainant as his partner. Though the accused had stated in his cross-examination that when he heard about the misuse of a check by the complainant, then he wrote a letter to the bank, but he has not mentioned the check number of the check in question in his letter to the bank. During his cross-examination, the complainant has admitted that he had filled the particulars of the impugned check. Even if the accused takes the plea that a blank check was given to the complainant, the said fact does not dilute the liability of the accused, as legal position of inchoate instruments is well settled. Section 20 of the NI Act provides that if a person signs and delivers a paper stamped in accordance with law, and either wholly or blank to have written thereon an incomplete negotiable instrument, such person thereby gives prima facie authority to holder thereof to make or complete, as the case may be, a negotiable instrument for any amount specified therein and not exceeding the amount recovered by the stamp. The primary defense of the accused is that the complainant was only an employee and he never invested rupees 15 lakh in the contractual works, and he had misused the check which had issued for payment for provident fund. In support of his contention, he alleges that the complainant had not filed any documents in support of the amount given to the accused. It is further alleged that the amount has not even been disclosed in the income tax return of the complainant. However, neither any complaint or FIR was lodged regarding the misuse of check by the complainant, nor were the employees of the accused who were working under him examined to prove the complainant was also an employee of the accused. This definitely hampers the case of the accused, especially in light of the fact that no other evidence has been forthcoming in support of his claim of innocence. It is well settled principle of law to catena of decisions that the statutory presumptions available under section 118 and 139 of NI Act are mandatory in nature. They are rebuttable ones. It is needless to say, when the complainant proves the requirements of section 138 of NI Act, the onus of proof shifts and lies on the shoulder of the accused to rebut the presumption available in favor of the complainant. It is the accused who has to rebut presumptions with all preponderance of probability with clear, cogent, and convincing evidence, though not beyond all reasonable doubt. It is also equally true that if the accused places such evidence to show as to disbelieve the case of the complainant, then the presumptions stand rebutted. Now, the question that would arise is whether the accused has rebutted the statutory presumptions available in favor of the complainant. The counsel for the accused submitted that there was no existing debt or liability on the date of the issuance of the check, but the accused failed to substantiate his claim. The Honorable Guwahati High Court in Ambika Baisya versus State of Assam and another held that the holder of a check shall be presumed to have received the check in discharge of date of liability which drawer of the check had, and presumption cannot be discharged by drawer by merely offering a reasonable or plausible explanation. The presumption can be discharged only when the drawer proves that he had no such debt or liability as the sum mentioned in the check reflects. But in this case, there is nothing from the part of the accused to rebut the presumption that the check was not issued to discharge any liability in part or whole towards the complainant by him. The accused has contended that the complainant had misused his check, but he failed to produce any materials on record to show that he has taken any action against the complainant after coming to know that the complainant has misused his check. In my considered opinion, it is now well settled that in case the accused admits his signature of the check in question, there arises a presumption in terms of Section 118A and 139 of the ANA Act to the effect that the same was issued for valid consideration and in discharge of legally enforceable debt or liability. Learned counsel for the accused has also contended that the complainant was an employee of the accused. However, it did not lead any evidence to prove the same. Also, the plea of the accused that there was no existing debt or liability is of no help in view of the admitted signature of the accused on the check. The defense could not rebut the presumption cast upon him. So, in my opinion, it can be presumed that the check was issued by the accused, the complainant, to discharge his liability towards the complainant. Hence, from the above discussion, it is held that the accused issued the check for discharge of legally enforceable debt or liability towards the complainant.
So you have read the evidence, nothing else. The learned magistrate have considered all the aspects which you are claiming here.
Yes, Lord.
Then what remains? Since you have failed to prove that account, now can you raise that issue in this revision petition?
Now, Lordship, there are questions regarding the financial capacity of the complainant to disburse a loan of 15 lakhs.
That's what the learned magistrate considered 118.
Yes, Lordship, but
Then
yes, Lordship, that is true, but
that's it. That's why I'm saying at this stage, the revision,
Lordship.
which was not considered, and then the appeal also, that is considering this evidence,
Lordship.
while in what basis this particular finding is bearing law. Because this is on the basis of evidence, which at that point of time you have failed to place. Can you take that, can you raise that issue now?
Yes, Lordship, now
See, that's what you are supposed to do at that stage.
Lordship.
We are in the revision stage. You have also
Yes,
appealed
Lordship.
and the appeal was dismissed
Yeah.
because of a similar reason. Now, after reading this evidence, after reading these findings of the learned magistrate, just tell us how it is possible to consider.
No, Lordship, the learned, magistrate, the learned magistrate considered that the proof of evidence is preponderance of possibility.
Definitely.
Now, definitely,
That is
that's
the
the case,
NIT
Lordship.
Act. That is why in the NIT is not like other criminal.
Yes,
cases,
Lordship.
right? So
Lordship, and that is why, Lordship, when he had specifically mentioned in his reply to the advocate notice that accused had
learned magistrate has considered each and every aspect that you have claimed here. And how you have failed that also been exposed. But these cases, how we can interfere? Where is the ground? Consider your prayer at this stage. Was any lacuna in this particular finding of the learned magistrate?
Lordship, the main lacuna is the, non-consideration of the financial. That is one of the main lacunas. Also, Lordship,
That is under the 118, right?
Yes, Lord.
So where is that? The finding of the 118 is very clear. How you have failed in proving 118, the learned magistrate has considered it this way. That's why we have asked you to read so many
Yes, Lordship, I
paragraphs,
understand that.
not only single paragraph,
Yes,
right?
Lordship. Yes,
At
Lord.
least to the finding of the learned magistrate.
Yes.
Why that prayer, why 118 that you have claimed was not considered? Why it was not? Learned magistrate was
But
specified.
Lordship, here in the trial court has also been quite lenient towards the complainant. Lordship, the complainant, he has stated that he had taken loan.
Definitely, for that is the reason do it not prove.
Lordship.
But you are the accused.
Lordship.
It was your duty, which you have paid. That's why because you have given the signature, there is no doubt that the check was dishonored.
Lord.
You have failed to establish the fact that the check that you have issued, whether it was blank amount or whatever it is your signature, you have proved that signature.
Yes,
All the contraries, whether it was for the provident fund, that also you have paid. As one you have said it is for payment of electricity bill, that was also been considered. With regard to 118, that has also been considered.
Lord.
You have to give us certain handle.
Yes,
to
and
India
also,
court.
Lordship.
That thing is not there at all. The
Yes,
learned magistrate have considered entire aspect.
one aspect remains, Lordship.
What is that?
Lordship, the check that has been issued from the account, that is the official account of the partnership firm, as claimed by the complainant, Lordship. Please have a look at page 36, Lordship.
What is the finding on that?
There is no finding on that, Lordship.
There is a finding.
No, Lordship.
You just see.
I don't think there is any finding on that, Lordship. If I may kindly read, Lordship, para 9 of page 36, Lordship.
Yes.
Lordship. The partners have, for sake of convenience, for the time being, mutually decided to carry on operating the already existing bank account with HCFC Bank GS Road branch number Iman, standing in the name of proprietorship firm. However, it has been mutually decided by parties that immediately on execution of the deed, the partners shall approach the concerned bank to do the needful for transferring the account to the name of the partnership firm, and all monies, checks, and other securities belonging to the firm, except those required for current expenses, shall be paid into or deposited in with the said bank. Now, Lordship, this is the official account of the partnership firm, of which the complainant is also a partner. Because no new account has been opened, Lordship. If a check of this account bounces, I mean, if it gets disowned, the complainant is also equally liable, because he is the partner, and this is a registered partnership deed, Lordship. It's a vital aspect, Lordship. How can one partner of a registered partnership firm sue other partner for a check of the official of the official bank account of the registered partnership firm, which has found?
That is the issue.
That is the issue, Lordship. And Lordship, the accused has also, the respondent has also stated that he has executed work orders amounting to ₹50 lakhs, Lordship. The accused had also, Lordship, failed to prove a single iota of evidence that he had either executed work
That's what
order.
the learned magistrate had considered that aspect, because it is with the accused.
That is my prayer, Lordship, that the considerations are wrong. The preponderance of possibilities principle, Lordship. The possibilities of, the preponderance is with the accused in this respect, Lord. Because he has been consistently he has consistently stated that accused does not have the financial capacity. From his notice to his cross-examination, Lord. And Lordship, the trial magistrate has also deviated from this point that in his complaint petition, the accused has stated, the complainant has stated that he had borrowed loan from 10 to 15%. However, in his evidence, he has differed. He has stated that he has taken loan from his relative, and that too from those who are not authorized to do so.
How the appellate court has dealt with that point?
The appellate court is also silent,
That
Lordship.
may be one of your ground in the appeal. What is the ground before the London appellate court?
That point was raised, Lordship. Yes, Lordship. That was the ground.
How the that particular ground was deliberately appeared for.
That ground has not been, I mean, properly decided by the learned appellate court, Lord.
That was not your ground.
That is, Lordship, that is was the ground. Page 4, page 150, Lordship.
Okay. Your ground number 12. Let us see what is the consideration. Mr. Nath, it's just one finding.
My lord, first of all, that is never be a
No,
ground.
no, no. That is not the issue. Come to page number 172. Para 23.
172, my lord, yes, para
23.
23. Yes,
In that case, what is the liability? No doubt it has been issued by the, signed by the applicant.
Yes.
And the name and the amount incorporated by the complainant.
yes.
How the liability has been proved.
My lord, blank check, because the signature has not been disputed by him.
There is no dispute, but what is the liability? In that case, what will happen?
Well,
That the
Blank,
person who has given the signature admitted the check, but what is the liability?
my lord, there is a judgment, because the appellate court had relied on the judgment. Veer Sanghvi, my lord. Veer Singh, 2019 4 SSC 197. Page 166.
Yes.
Number 4, it deals with that question, my lord, specifically, blank check. Because that question was raised and specifically decided both by the trial court and the appellate court. It was discussed in great detail.
Okay, we'll come back at 2. Mr. Das, you are sitting for which item?
Copy has to be given. For the first time, my learned friend is appearing. So I will serve the copy to my learned friend.
My lord may hear it on Tuesday or
Tuesday or Wednesday, whichever is convenient.
30th or 31st. Next week it will not be possible. Week thereafter.
Only one difficulty is that, my lord, from 6 to 9, there will be some problem. After that, my lord,
Week commencing from 12th.
well, yes,
My lord, I'm sorry, my lord, I will be out of station until the 21st, my lord.
after that,
Then after that, my lord.
whichever.
28th of August, my lord, 28th, my lord.
No, yes.
And
Yes.
Yes,
Okay. 20th, there is an interim order which will continue.
Item 12, right?
12.
My lord. Okay, we'll pass the order.
I think interim order will continue.
That will.
Deeply order.
Oblige. Lordship,
Yes, Mr.
Lordship, I have a hearing matter in court number 21. Lordship, can it be taken next week, Lordship?
Okay, we'll hear you in that case 3830. Will remain as part of.
Lord Mechanic, keep it as a part heard matter.
38th,
When, my lord?
38th, next Tuesday.
Next week.
Much obliged.
Lordship.
Much obliged.
CBI counsel has asked me to take a date on 16. If Lordship, I have to take one important
16th of August.
August. Oh, Lordship, no,
12.
12 August, Lordship. I beg to apologize, 12 August, Lordship.
Lordship, I'm on behalf of Mr. M. Halloy, special petition.
Okay,
Obliged.
Like it. Prayer of the council for the part. Yes. Okay. All right. Yes.
Lordship, CD is not available in our office, Lordship.
Is it?
Yes, Lordship.
But there is an order earlier that
Short date, may be given on August, Lordship.
Pursuant to the order dated 31/05/2022. The officer in charge of the officer in charge of the Kolabanda Police Station. So I'll place the up-to-date case diary relating to scan copy of the touching text of the Kolabanda Police Station case number 47/2022, along with the report of the concerned investigating officer of the case. List on 20, list on 30, today is. Okay. 29.
19 of August, Worship.
19th not possible, 21st.
21st, Worship.
Copy of this order to Miss Andas, London Additional Public Prosecutor for her necessary use.
Lordship, on 25/7/24 was fixed for CC, Lordship. Charges are yet to be framed, Lordship. Five witnesses are there, Lord.
No representation on behalf of the particular on call. So name of its counsel has been reflected in the court case. RMS and thus an additional public prosecutor for the state respondent number 1 and Ms. MK Brown, right? Learned additional learned. I might just give it for the respondent number. Registry has already received the relevant records that was called for by order dated 14/03/2024. List again on 7th of August.
Correct. No, it's
There is no such letter by which Mr. K.P. Pathak has been appointed as a legal aid counsel. Don't know why in the cause list, his name has been reflected.
Yes,
There is no letter. Today is the date fixed for appointment of any such legal aid counsel.
legal transfer now.
17. No, please, madam.
Yes.
Madam, Mr. K.V. Patel has been appointed as a legal counsel here. So he's in another court, my lord, in Lakes. Perhaps, my lord, lordship may admit this appeal,
Not in absence of him. Ask him to come.
my lord. It is, my lord, matter may password for the timing, my lord. He will be here.
Ask him to come before rising.
Yes, my lord.
May I please your lordship? Lordship, we have filed this revision against this impugned order, lordship, that is on page 18, lordship. Against the rejection of Zimma, lordship. Cattle, lordship.
Cattle trespass section. Cattle trespass. Cattle preservation. 2011. Cattle preservation. অসমৰ এখন আছে। Cattle trespass, no, preservation. Assam. এখন লাইব্রেরি পড়ু একটা এখন বের একটা ও আচ্ছা। Ready to guard button. Yes, Mr. Saria. Considering the provisions of section 11(5). Considering the provisions of section 11(5), the learned magistrate rejected the claim of the petitioner. So, though there is a report from the concerned officer that these cattle seized are not required for the investigation of the case.
That we have to call for lordship.
There is no such provision under this act to give
Jimma of the
the
cattle.
seized cattle.
Except cattle, everything can be done.
So it has to be given only to the institution. In that circumstances, whether and further, the
Primacy after on perusal of the FIR lordship, it cannot be given lordship because those who are kept, but
Stolen, they are
Stolen,
found to be from jungle.
lordship. So only some, there are some cows lordship which are transporting for the purpose of cultivation lordship.
Lordship, these
Those may be.
cows, Lordship, these were not transported cows actually, Lordship. They were recovered from my house, Lordship. These two persons have been named in the FIR. I am not that
But
person.
there is an appeal provision under section 12, if any such order is passed under section 7 or section 11. Here the rejection has been made under the provision of section 11(5).
Lordship.
So whether a revision petition will be applicable, because the learned magistrate rejected that
Lordship.
Bhima will seize cattle under section 11(5).
Lordship.
And section 12 of the act clearly reveals that appeal any such order passed by the magistrate under section 7 or 11, appeal is required to be preferred. Why should you entertain this revision petition?
Lordship. It is before the session judge lordship.
Absolutely. Will not interfere. Either you withdraw or you dismiss, you approach the appropriate forum, up to you.
Lordship.
Lordship, in this case, Lordship, kindly some time may be given, Lordship.
What time? These are the matters you know, you have to wait till approve.
To satisfy, Lordship, some time may be
Question of
given.
satisfy the provision, it is an act. Is there any provision?
If they approach earlier, then the approach person in one rejection.
No, there is no mention.
They have not approached us.
Heard Mr. P.K. Das, counsel appearing for the petitioner. And Mr. P.F. Sahria, additional public prosecutor appearing for the state. On the basis of special information, police personnel from Bogri Police Station, the district of Pokrajhar, while making search on the night of 16/04/2023 around 15 hours. Recovered 11 numbers of stolen cows, nearby the inside his uncle, nearby the house of the accused persons, namely Zakir Hussain, Jagir Hussain, and Sirdul Asayati, who managed to escape from the said place. After recovering those 11 numbers of cows, and for Pooper and for their proper medical treatment. And to provide him shelter. Police from Bobrivali Police Station took necessary steps and lodged an FIR on 18/04/2023. On the basis of the said FIR, Bobrivali Police Station case number 48/2023 under section 379/411/34 IPC, read with section 13 within bracket 1 of the Assam Cattle Preservation Act 2020-21 was registered corresponding to GR number 298/2023. The petitioner filed an application for Zimma of those 11 numbers of cows, stating that out of those 11 cows, 4 were seized, 4 cows were seized from his house. That were legally brought by him from one by Hat Ali on 10/02/2023 and 01/04/2023. For farming by executing sale agreement. Petitioner also stated that he is not a named FIR, named accused in the FIR relating to sale. Bobrivali PS case number 48/2023. But the learned magistrate learned subdivisional judicial magistrate within bracket Sadar bracket close Pokrajar by order dated 28/08/2023 rejected his appeal, his application for Zimma of 4 such cows out of 11 seized by Bobrivali police relating to Bobrivali PS case number such and such. Hence this revision petition. Section 12 of the Assam Cattle Preservation, Assam Cattle Preservation Act 2021. I think. Provides for appeal against any order passed by learned magistrate under section 7 and section 11 of the said 2021 Act. Before the provides for an appeal before the learned session judge, having the jurisdiction over the area in which having the jurisdiction. In any property to which such orders relates, has been seized. Complete curriculum. In the case in hand, The petitioner, after rejection of his order of Jima of the 4 cows out of 11 says in said PS case number, without resorting the provisions of appeal as specified in this, as specified section 12 of the statute on the map, preferred is petition, revision petition against the order of the learned STCM Mudin Bucket S. The red 2803. Petition. Being not mentally. The petitioner may approach the appropriate forum as follows. If so,
Apply. Lordship, I beg your pardon, I wasn't like.
I will.
Actually, otherwise, I'm appearing as a legally.
Legally appearing for the appellant. Also heard MS and us under additional public prosecutor for the state. By the imperial judgment dated
21/12/2020.
21/12/2023. Planet Session Judge Asif Sagar in Sessions case number 251 within bracket S dash S bracket oblique 2014 arising out of the mode of PS case number 103 oblique 2012 convicted the appellant under section 304 part 1 of the IPC and sentenced him to undergo rigorous imprisonment for 6 years with fine of rupees 10,000 in default, simple imprisonment for 3 months for committing the offense, said offense in the section. Remitting the sentence already undergone by him. Remitting the setting of during the investigation and trial outside. Agree with the say judgment and order of conviction dated 21/12/2023 of the Session Judge Sagar. First, he convicted appellant has prepared this appeal from the appeal be admitted for hearing. All for the records of Sessions case number 251 in bracket as bracket close of 2014 within bracket arising out from the court of Planet Session Judge Asif Sagar along with the records of Pimo Police Station case number 103 of the list on sixth of September.
Deeply obliged.
You have been furnished with the memo of appeal, you have been furnished with the judgment. Copy of
Only the,
judgment?
yes, judgment I have required.
Formal format. Open to do each one. Next one later. Yes, Mr. Sekia.
May I please, Lordship? Lordship, we have filed this revision, my lord. Initially, my lord, what happened, my lord, the opposite side, they have constructed a, my lord, gate in the public road.
Hmm.
And against that, my lord, we have filed an application before the additional district magistrate
Hmm.
to draw up a proceeding under section 133 CRPC and to stop the construction of that, my lord, remove the construction of that gate, my lord, from the public road. My lord, by the order dated, my lord, this is at page, my lord, 16. The learned district magistrate, my lord, after, my lord, perusing the police report, passed an order, my lord, whereby, my lord, proceeding has been drawn up under section 133. And the other side was, my lord, directed to remove the construction.
Hmm.
Then against that, my lord, they have preferred, my lord, revision before the, my lord, district and session judge, my lord, Kasar.
Hmm.
District and session judge, my lord, he has passed an order whereby, my lord, he has stayed the, my lord, order passed by the additional district magistrate, my lord. The order passed by the additional district magistrate Kasar has been, my lord, stayed. And against that, my lord, we have come before this honorable court, my lord. And this honorable court, my lord, had, my lord, the initial order, my lord, stayed the order passed by the district magistrate, my lord, passed by the magistrate, my lord, district and session judge Kasar, my lord. Now, my lord, my lord, my prayer is that, my lord, appeal may be admitted, the revision may be admitted, and my lord, may come for hearing, my lord.
My lord,
The other side is appearing, my lord.
my lord,
And now by this time, my lord, after passing the stay order by this honorable court, they have completed the construction, my lord, violating the court's order, my lord. I have given the, my lord, photos also, my lord, at the annexure 2, my lord. Lordship will find, my lord, where they have constructed. This gate is now complete. They have put the, my lord, gates and everything, my lord. It is now, my lord. I have the recent, my lord, photos in my mobile, but, my lord, I could not look out a printout, my lord. There is no wrong, my lord, passed by the additional district, my lord. He has drawn a proceeding. And, my lord, he has passed an interim order to, my lord, remove the construction, my lord, because it comes, my lord. My lord.
Yes, you're appealing for whom?
my lord, I, for responding, my lord. My lord, first of all, this is not a private, public road, but a private road. Private road on private name, the name of their grandfather, my lord, their father, in the Saidali Majumdar. They are, their nameplate is there, my lord. This is nameplate, my lord. This is nameplate. In the front of the road, my lord. And my lord, there are the other part is that only safety of their children person, my lord, there are, they have installed a gate, my lord. And nobody, there are nobody prohibit any person, my lord, from ingress and outgress, my lord, throughout the gate. And during the first revision petition, as session judge Silchar, my lord, they filed the second revision petition, my lord, before this one honorable court, which is not permitted
This is
in the eye of law.
482,
Under section 397(2).
this is 482 petition. It's not second union.
Nowhere mentioned their involvement in this road, my lord. Oh, this is wholly on their private land, my lord. The road is constructed by them, this family, my lord, Ghulam Raja family, and his father.
Will appear for the state.
There is a police report saying that it was a public road,
That's what.
a common public path which was used as ingress egress by first party and other inhabitants. And the stay order has no regions as such. That's what I was trying to find out, whether regions are required to be given. I have to kind of say.
133.
153, while staying that order.
No, 133, 4 price, 133. It is 188, 188, 88, it's 188. 33 what time, regions may come, regional, and buildings are there. No.
Oh, no. 480 in the guise of second.
In the
Miss Jahan, but this photograph doesn't show that there is a gate. It says a kind of post.
Well, by now, my lord, gate is there.
Where is there?
Gate, my lord,
Photograph that they have in it.
that was, my lord, the next step, when we have filed that, my lord, that is the, my lord, photograph of the position, my lord. Now, my lord, the latest position, lordship, I have one way, the lordship will find the gate is now, my lord, fully constructed.
That's an
I have
item.
one, my lord, photo in the mobile, lordship may see, go through it, my lord. Now, my lord, they have put the gate and my lord, they have put lock and all, my lord.
In session judge, they have failed any document, my lord, showing that it is public land.
My lord, the one I am
Hmm.
They have put the gate, my lord, after passing the stay order by this honorable court, my lord.
Reaching that hand, 3 days. Yeah, yeah.
Please come to page number 19, Ms. Jha.
That's the prayer on 19.
19.
For that, the alleged part is the private part.
Hmm.
Of revision is second party and the second party did not close or create unlawful construction over the said part. It is clear from the police report that the second party revision is started at gate over the alleged part as because the said part said part belongs to him. And the said path is open for that the children can easily go out to the main road. The revision is second party wanted to construct a gate to save the children from his family, children of his family or other children of the first party from any certain extent. The revision is second party never created an unlawful construction or objected the first party, opposite party to move in this part. This is the bone of contention. They are saying private and the police report says it's a public road. Police report as such is not annexed.
My lord, my humble prayer is that, my lord, the district magistrate, my lord, he will look into the matter, my lord, fully. He will hear both the sides, my lord. Now he has passed an interim order restraining them from constructing the further construction and to remove the construction and to have
do
drawn
one
up a proceeding, my lord. Let that proceeding be completed, my lord.
Will direct the district magistrate to hear both the parties, obtain the report afresh from the police. And then
They have in fact heard both the sides
I don't think so. This
in revision. Heard both sides.
should
I've
be,
gone through the material from record.
but the contention of the other side, second party is that he was not heard. It is there in the pleadings.
Issue notice to be responded, but
On 34/24, notice has been issued only. We are not present actually.
perhaps it's a psycho-style statement heard both sides. Otherwise, issued notice to be responded.
That was an interim order.
Interim order.
Against that order, the second party approached the London Session Judge for the revision.
Yeah, it's an order, isn't it?
Ma'am.
So this is the order that they have put in challenge here.
Interlocutory order. Now, this order is not challenged. This order was challenged by the second party, the respondent number 2 hearing,
Huh, yes.
because there is a direction to execute the order removing the obstruction.
Lordship.
Then the Leonard Session Judge spot that order at page 22.
Lordship.
Ultimately, it has to be decided. It's not finally decided.
Not final, it's only a stay order. Let them finally decide by hearing the both sides of the report.
Lordship. And my lord, till then, my lord, this, the order passed by the session judge that may be, my lord, set aside, my lord. And the direction may be directly given to the, my lord, additional magistrate, my lord.
We'll set aside that order. And then we'll ask the concerned magistrate to hear both the sides.
Lordship.
Until that matter is disposed of. The first party able to have the egress and ingress from that.
Right.
At this moment, we'll not say of removing the obstruction, but they will be used to egress and ingress this. That much we have. Right. Dispose of the direction.
Yes, absolutely.
Yes.
Item number 41 from supplementary.
Lieutenant Lagan.
Yes, Mr. Gogoi.
The person was convicted under 3042 for 5 years, my lords. The date of conviction is
Just,
from
a minute, just, a
my
minute,
lords.
let us walk out.
চাৰি বছৰ আত্মা হৈ গ'ল।
Punishment is how much?
Past 5 years.
Oh, remission হলে হয়ে যাব
এইটো period ধৰাই নাপায়।
remission period হলে
আৰু এইটো যদি আমি ধৰো
set off.
set off টো 4 মাহ আছে জেলতে আছে।
Almost incarceration period is over. আছে নেকি তোমাৰ fine? নেকি নাই?
আৰু conviction দিয়া সময়ত তাৰ বয়স 52
Oh,
এটাতে
আচ্ছা।
retire গ'ল।
304 part 2.
But direct হোক এটা গোপে
Sentence
300 of exception court কৰিলে।
Mm. 5 years.
এইটো সেই লগে মেকআপ কৰিছিল। 5 বছৰ আত্মহত্যা হ'ল।
Oh. Judgment day part ধৰছা ন?
এইটো
আৰু
হয় নাই
during trial তো সি থাকিব পাৰে?
থাকিব পাৰে। এইটো দেখাইছে এতিয়া এইটো arrest হৈছিলে এইটো। চাৰ্জশ্বিট দি দিছে এপইণ্ট কৰি দিছে কিন্তু এই চাৰ্টিফিকেট মানুহ হ'ব।
হ'ব পাৰে, he was
তাতে থাকিলে বেইল নে বেইল জেলত
আৰু হ'ব পাৰে গোটেই ট্ৰায়েলটোৱে জেলত আছে। অৰ্ডাৰ শ্বীটত ওলাব। He is a man.
He was already in custody.
My lords. And also, my lords, I couldn't find any material that he was ever on bail because the offenses of 2017. My lord, the second bunch which I hold, it says where he was, it doesn't indicate if ever he was on bail. My lord. He is in jail from his date of arrest.
No, the order sheet itself reflects.
Yes, my lord.
I am going to the order sheet of the Sessions Court.
He was in jail throughout, from the day of
He was
arrest.
arrested on 14th of April.
14 April, my lord.
17.
Let us see the judgment.
14 April 17. And judgment even uncle hall? 15/11. 17 no. Oh no, yes.
Judgment 2 বছৰ পিছত আছে।
These 2 years he was also there inside.
5 years.
And after this bail is filed, no bail. After this appeal, no bail. The appeal is filed 5 years. এতিয়া বেলৰ কাৰণে অলপ মুভ কৰিব লাগিছিলে ন? 4 বছৰটো ইয়াতেই গ'ল।
He has already completed.
Yes, my lord.
Already completed. More than 5 years.
More than 5 years.
7
On
cumulative.
13th of April 2022, he has completed 5 years.
Lordship will direct him to release forthwith with a direction to the superintendent. Yes. Four years gone in High Court itself.
What, Mr. D. Gogoi, your legal
Amicus,
counsel,
Amicus curiae.
plenary amicus curiae for the appellant. Also heard Mr. MS S. Dahan, London, additional public prosecutor, appearing for this state. A judgment dated 15/11/2019 Passed by learned session judge Kamrup, learned session judge Kamrup, Nagaon. In sessions case number 121/2017.
মানে 20 ৰ কিবা order আছে নেকি চাওঁ।
Arising out of Buko Police Station case number 157/2017. Corresponding to GR number 585 within bracket capital K oblique. K bracket close 2017. Convicted the appellant under section 304. Part 2 IPC. For causing death of his father by inflicting dow blow on his neck in a sudden fight. And sentence him to undergo rigorous imprisonment for 5 years, 5 years, setting off the period under detention already undergone by him during the period of investigation and trial of the case. Agree with this judgment of conviction and sentence dated 15/11/2019, paragraph 4 elected. Passed by learned session judge in sessions case number 121. Session judge Kamrup, Tamil Nadu. In sessions case number 121 of 2017. The said convict preferred this appeal from jail. By filing application on 09/01/2020. This court on 17/12/2020 admitted this appeal for hearing. After 17/12/2020. Earlier, Mr. Kaushik Goswami, an impaneled amicus curiae of the Guwahati High Court, was appointed as an amicus curiae for the appellant, who in the meanwhile has been elevated to the bench. Be careful. Senior advocate, an advocate of this type. However, after 17/12/2020, it is in Billikanil, however. 17/12/2020, this matter was last listed on 17/7/2024. And Mr. Dixit Gogoi was appointed as an amicus curiae in the matter. From the records of the case, it is seen that the convicted appellant Sri Tanak Boro,
Tarak Gurumani.
sorry, Tarak Boro, son of Mohim Boro, Mohin, may I add, resident of village Durapara, Durapara. Under police station Boko, district Kamrup. Was taken into custody on 14/04/2017 itself. After Boko Police Station case number 158/2017 being registered on the basis of an FIR lodged by one Kulen Boro on 14/04/2017 before the officer in charge of Boko Police Station relating to the incident that the convicted accused in a family issue fought with the father of the informant and killed his father by giving dow blow on his neck while the informant was away from his house. Case record also reveals, and accordingly, Boko PS case number happens because registered on section 302 against it. The records also reveals that during the entire proceeding, during investigation of said Boko PS case number such and such, and the trial of such license case number such and such arising out of Boko PS case number corresponding. The accused appellant, the convicted appellant was in custody since 14/04/2017. As such, he has already completed the 5 years period of conviction and sentence under section 304 part 2 way back on 13/04/2022,
in terms of the impugned judgment, the conviction and sentence dated such and such. In view of the above, the Mr. Gogoi,
My lords,
difficulties whether in the central jail in Guwahati or in West Indies, let us see only.
my lord, we will
When
find
the
this.
letter is- let us say first.
Central jail, my lords. The forwarding is from central jail. Got.
Is forwarding.
In fact, the petition has been attested, the signature has been attested by Assistant Jailer Central Jail.
In view of the above. The.
Yeah.
Superintendent. Terracotta sentence. In custody, no? At Central Jail, Guwahati. In view of the superintendent of the Central Jail, Guwahati. Shall forthwith release the accused appellant, namely such and such, son of such and such. From jail. Relating to case number variety of such and such. Judgment and conviction variety. If not wanted, but in any other case. Or if not been kept in custody in any other case. Registry shall return the case record of such and such case number to the court of London and that's Kamruk Lingam. Court will tell them a copy of this order. The registry shall also communicate this order to the central superintendent central jail. Kamruk Metro Guwahati, forthwith.
Acknowledgement.
Criminal petition, 20.
No, it's always a competitor center. Release of the document. If you order, believe it. If not, very. If not already released.
The petitioner side is not here. It has come up for orders.
None appeared for the petitioner on call. Even on last two occasions, I on 14/12/2020 and 05/05/2020, the petitioner remained unrepresented. Though names of two councils have been reflected in the council cause list for the petitioners. RMS as Jahan or additional public person. It is seen that there is a stay order in force since 03/04/2017 and pursuant to the order of the court dated 03/04/2017, the petitioners have deposited an amount of rupees 7,500 as litigation cost with the registry of this court. Placed again on 31st of July.
You're gonna, huh?
But kindly please the order statement 11/8/2023. Yeah, it remainder was. Okay, sir, taken through the OC Patasar Kushi as well as district state board of time.
Question? Question of complaint to them. About Fox. Stay as a second. Then.
That is complete one.
Yes, to who is a second all of trial who is it? There is no stay, perhaps the trial has undergone quite some extent.
You are appearing for the petitioner.
Hello?
You are appearing for the petitioner.
Yes, sir.
What happened with the trial?
Look, it is in the evidence stage now. It is going on.
Are you sure it is in the evidence stage?
No, well, next date is 29, my lord. No, next date is 29, coming 29. Next date. I don't know. But my lord, only due to the non-completion of the service, my lord, on this point number 2, my lord.
पाँच बरसों हो गए, 5 बरसों Fox से कोई मान नहीं लगने. Trial?
Several occasions, my lord, it was taken, my lord. Well, only basic cases, my lord, the petitioner submitted a highly petition, my lord, for DNA test. And that was rejected, my lord.
Oh, अच्छा. DNA test or reject person against that yes, huh? Hmm. In 2019 itself, it was the stage of defense evidence. Now also it's going on. Argument 23/5/2019 was fixed for argument. Cannot be a different evidence stage now. Let him take instruction what has happened to the case. अरे एक ही तो ट्रायल कोर्ट हो सर्विस कंप्लीट में या फिर वन है स्टे होना है लेकिन ये तो देखिए बोल सके आर्गुमेंट हो रहा है 19 आज बस हो बोलो फिर खबर लो बस देखिए बोलो
ना 29
Later on, NBW was issued, he was arrested.
My lord.
What happened thereafter? That's in 2019. Initially, bail was granted by this court.
Yes, my lord.
Thereafter, what happened?
Thereafter, my lord, he was again detained, my lord. He was sent to the jail, my lord.
He is in custody or outside?
Presently, my lord, he is outside, my lord.
See, the reason is only that application for DNA was rejected. That's the order is at page.
20.
20, 20. That cannot be a ground to interfere at this stage.
Hmm. And DNA, it's only corroborative, even he's a father or not.
That doesn't mean required because if you see, if you read the FIR, very clear at page 12. She was a minor, she was threatened. Consequence was not understood by her. And she was asked to keep silent. Only when the menstruation cycle stopped being inquired, she was compelled to answer. In that circumstances, there has been fight. At best, we can have the scanned copy of the
That is what I was thinking, along with the order sheets. Or he can
the
bring it.
order sheets and that will be faster. And then statement of the
Victim and all. If they are consistent, if the statements are consistent, that would end, that would be the end of the matter. Otherwise, lordship will go to the corroborative evidence, then DNA may be considered.
But Mr. Asok counsel appearing for the petitioner, NMS as the hunt, but notice has to serve because
That will be a corroborative evidence.
when is the next date?
29.
You will inform. Your responsibility.
Go to inform because the court records are called High Court. Order place করলে হল
MS
order
has
তো
done.
is place করলে হল interest rate
This is public prosecutor appearing.
29 Monday নি oh yeah orally provided
Petitioner is directed to serve copy of this criminal petition to the London Public Prosecutor of the High Court on or before 29/07/2024, obtaining necessary acknowledgement along with the agreement. Thereafter, in the office of the Public Prosecutor, Guwahati High Court, Guwahati, obtaining necessary acknowledgement. The order to Achana, to inform the respondent number 2, namely Robin Talukdar, son of late Ganeshwar Talukdar, resident of village Ujan Ulua, Mouza Uttar Bojali, Police Station, Patasar Kusik, District Bojali, erstwhile Borpeta, Assam. To the officer, to the, and after filing the deportation, police stations are there, Patasar to the police station. Mr. Hawk, Planet Council appearing for the appellant submitted that next date of the case is fixed on 2907/2024 and a special POCSO case number 11/2016 arising out of Patasar Kusil Police Station, Patasar Kusi Police Station. Case number 779/2016 involved in this criminal petition. As such, the counsel for the petitioner shall also apprise about this fact to the learned special judge POCSO in said, right? Special POCSO case number 11 has been about this criminal petition number 972/2019. List on.
Stop that.
28th of August. Call for the scanned copy of the records of special POCSO case number 11/2016 from the learned session judge POCSO Gozali Patsama. Special judge, right? Session judge slash additional session. List of judges.
My lord, 29th is next Monday, my lord. Can I have this copy of today, my lord? 29th is next Monday, my lord.
It will be updated in the.
My
We have to write, if any stay order is there, give the numbers. We have a reference at 3:30.
Apply.